thank you all for coming, for the speakers and for those who are listening in and for those who will be listening in the recording. Thank you for coming in. So this is a talk about this book, Comparative Administrative Law, an Introduction, published in Edward Elgar, 2025, and we have both of the two authors here. So Professor Napolitano and also Dr. Perona. Thank you a lot for agreeing to host this talk and to talk about the book. And we also have Dr. Bowie from UNSW, of course, very famous in common law administrative law circles. And so it's a lovely thing that you also agreed to come and talk about this book. And as the minion in this talk, I shall say I look forward to the conversation. So I suppose I should hand it over to the authors to decide how they want to go about it. So the structure will be the authors will talk about it, plan according to plan, if according to plan, maybe 20 to 30 minutes. And then Janina will come in and then talk about it for 10 to 15 minutes. And then the remaining time will be allocated to Q&A. So I suppose that's how we're going to proceed. But it's not a fixed schedule, so we can be a bit flexible with it. So, okay, please.
Sure. Thank you very much, Edward. I'm just wondering whether, Julia, you prefer to start yet, or I might begin, and then when Julia tells me, he steps in, and then we switch then.
You see me?
So, okay. So let me just
share. Can you
share.
see me?
Yes, we can. I will share the slides so that you can begin.
Yeah.
Perfect.
Yes, maybe while you prepare the slides, I can just make some few introductory remarks. First of all, explaining why we felt the urgency of working to a book like this one. We are, I and Leonardo and many friends and colleagues in Italy, passionate of legal comparison and of legal comparison in the specific area of administrative law, which is perhaps one of the less covered in the different areas of law. And we missed the overall picture. I mean, in the literature, there is plenty of very interesting papers related to specific issues, to very important topics, administrative justice, administrative procedure, regulatory state, independent agencies, and so on. But there is no real overall reconstruction of administrative law around the world in different jurisdictions. And in our opinion, this was a very relevant loophole, both for teaching and for studying, for legal research. For teaching, it's clear why, because it's very difficult to explain to students different stories without a guide, without a map, explaining where you are when you are discussing, debating a specific topic. But also for legal research, because of course, it's very important to deepen the analysis in relationship with the most relevant topics of administrative law. But I think micro comparison, also with reference to big arguments. I'm not saying that administrative justice is, of course, a small topic, but if you don't keep in mind the legal context, the constitutional framework, the different histories and cultures of legal orders, you run the risk of missing some important factors, some important causes that explain divergence and convergence. So both for a teaching purpose as well as to provide a framework for legal research, we decided to engage in this very challenging adventure. I started alone when Leonardo was still a student or a PhD student, and I wrote a book in Italian. And then, of course, I thought that that it was important to try to do this work in English so that everyone could read it. When first I contacted the publisher, and they called many colleagues to receive an opinion. I also remember that they asked Paul Craig an opinion on a first draft. They said, okay, that's very important, but are you sure that you will be able to make it? It's very difficult, of course. And then with Leonardo, that in the meanwhile had grown up and joined Roma 3, we decided, okay, the time has come and let's try to make it with some choices. So very shortly, before leaving the floor to Leonardo, let me explain the choices that we made to prepare this book. First of all, this book should not be too big. I mean, it should be a text in which students can navigate easily. So we need synthesis, of course. But we wanted also to provide a large picture. So we didn't want to limit our research to the usual Western world, to Europe, as many European colleagues do, or to the relationship with Europe and the US. So we decided to dedicate some attention, as far as it is possible, also to South America, to Africa, to East Asia, to Australia and New Zealand. Secondly, we wanted to stress the strong connections between administrative law and constitutional law. When I spoke about this book with Armin Bogdandi, he said to me, call it comparative public law, because it will be, the market will be much larger, but we didn't want to miss the focus on the specificity of administrative law, because there are many works and many books and also textbooks and treatises on constitutional public law from a comparative perspective, but we wanted to go more in details of the running of the administrative machinery. But at the same time, constitutional law is important for us to frame the different regulations of administrative law in various jurisdictions. The third choice we made is to focus after the chapters dedicated to the history and to the development of administrative law in Europe and in the different continents. We decided to focus on the three main areas of administrative law in function. So the organization, the procedure, and the legal protections. So when we decided to approach the three macro areas of administrative law, we decided to follow a functional approach. This means to select the topics, to select the problems underlying the most important institutions of administrative law, and then to analyze the different models and the different legal solutions that were adopted in the different jurisdictions. Of course, making once again a choice, deciding when we speak, for instance, about administrative procedures, which are the most relevant and advanced regulations of rulemaking or of adjudication, which is the dominant model, and which countries try to follow that model, even if, as always, with adaptations and creations, original creations, because we do not believe in legal transplants as an automatic device. And this is the approach that we followed in the various chapters. For instance, depending on the subject matters, making reference to US or to France or to South Africa or to Japan. This depends on the specific legal institutions that we analyze. This book has not a conclusion. I mean, it's just a toolbox, is just a map for stimulating the interest of students, and we hope future researchers, and to provide further materials for researchers and colleagues. I will stop here, and I will leave the floor to Leonardo and to the other friends to Leonardo for his introduction, and to you for questions and comments. Thank you so much. It was really a pleasure and an honor to have the opportunity to discuss and to present this book with you, with the friends of Conch University and of many others universities and research centers that are so fully involved in legal comparison. And also thanks to Janina, that of course was inspiring with his paper, with her papers. Thank you so much.
Thank you. So I will continue the introduction made already by Giulio, and we thought that a closer look at the contents of the book might have been useful for today's discussion. On the one side, to provide an overview of a possible systematization of comparative administrative law as a scientific subject, and of course, one possible systematization, not just the only one, of course. And on the other side, to allow those that haven't read the book yet to grasp an idea of its content. The book is composed of 6 chapters. The first one concerns history and methods of legal comparisons, aspects that have already been touched upon by Giulio by saying that differently from the evolution that characterized other branches of law, such as private law and constitutional law, comparative administrative law is widely recognized for having emerged with a certain delay. There are, of course, several causes for this. And one significant reason for this delay is represented and explained in the first chapter by the intimate connection between administrative law and governmental power, and therefore political power, political tradition, with the consequence that administrative law has long been considered an exclusively national product, in relation to which any legal comparison would have been both unfruitful and also highly impractical. Also considered that administrative law long remained unwritten in many legal systems. Of course, we explain in this chapter that since the end, at least since the end of the 19th century, the legal analysis instead became a common effort, also in a comparative perspective, and legal scholars in several jurisdictions started to practice and to refer to the comparative method for its inherently heuristic force. As far as the European continent is concerned, we anticipate in this first chapter and then further discuss in the second one that from the second half of the 20th century, legal harmonization within the framework of the European integration process, as well as the emergence of a multitude of international regulatory regimes, contributed to a stronger affirmation of comparative administrative law. Clearly, we recognize in this chapter that overall administrative legal systems gradually displayed significant convergence, as well as some cases of transplants. But as anticipated by Giulio, this notion is critically expounded in this first chapter. And needless to say, legal systems still maintain relevant differences, which are the outcome of several factors. Of course, I cannot go into the details here, but reference is to history, to political tradition, to the different economic developments of the various countries, to society, and more broadly to culture. Of course, all of these factors complicate comparative administrative law, not only as a legal sector, but also as a legal discipline whose instruments and methodologies are also discussed in the first chapter. Moving to the second chapter, the focus is here on Europe. And the chapter provides an introduction of the various European legal systems, emphasizing the emergence of administrative law here as a complex legal machinery serving the needs of the modern state, conceiving the modern state as one in which it is not only necessary to provide guarantees against the exercise of public power, but also to ensure services and social rights. Of course, we are aware that this link with the modern state has been recently and insightfully contested in part, notably by Paul Craig in his 2024 book on English administrative law from the 16th century and so on, continuity and change. But we believe that also in light of these intriguing new paths of research, a focus, first of all, on Europe was necessary and needed. of course, we refer to a traditional distinction, which has been conventionally drawn among the various legal systems between common law ones on the one hand and civil law ones on the other hand. But I think that we can all agree, as this second chapter clarifies, that such distinction is the product of a simplification in general terms, and that it is unsatisfactory and of limited usefulness for administrative law. In fact, a specific subchapter in this second chapter is dedicated to the limits of typification attempts, and also when we refer to the common law approach, we put it within quotation marks, and we use this expression mainly in descriptive terms. In fact, I mean, the evolution, the reciprocal influences and adaptations among the various legal systems render this distinction, and also more generally the distinction and commonalities among European legal systems, much more nuanced. But coming back to the chapter, after an introductory paragraph, the chapter then focuses distinctly on France, Germany, the United Kingdom, as well as Eastern European countries and Russia. As anticipated, a final paragraph is dedicated to European integration, a process which is, as I said already, particularly relevant for comparative administrative law. And that is for at least two reasons. On the one hand, administrative law and the legal traditions of the member states significantly contributed to the essential features of European Community and then European Union law. And on the other hand, given the force and influence of European Union law over national legal systems, European integration generated significant convergence in Europe. Moving then to the third chapter, we here clearly state that administrative law is not, of course, just a product of the European legal tradition, having instead a worldwide diffusion to which this chapter is, in fact, dedicated. Here we strive to remedy to the Eurocentric perspective and to broaden the picture, as was already clarified by Giulio. This is not to deny that historically certain European legal systems exercised great influence in the affirmation of administrative law in other parts of the world, especially as a consequence of colonial and commercial relationships. With time, however, Europe lost its monopolistic influence in favor of the increasing relevance of other legal systems, namely, for a significant period, the US legal system, to which the first part of this chapter is dedicated. In this specific part, we not only focus on the feature of US administrative law as such, but also we explore its direct and indirect influence abroad, including Asia. And then the analysis moves southward, that is, to South America, which, considered in terms of first approximation, can be described as a group of legal systems that draw inspiration both from Europe and from the US. By saying this in very brief terms, I mean that South American legal systems are deeply influenced by the US as far as constitutional arrangements is concerned, and by the European traditions as far as administrative law is concerned. A specific paragraph then is dedicated to the constitutionalization processes in Africa and to the affirmation of administrative law in the African continent. And then attention is devoted to the Middle East and India, as well as to East Asia, which displays limited links with European tradition, and especially when they do, it is mainly with regard to the British legal tradition. 2 paragraphs are then dedicated respectively to the Chinese legal system, which only from abroad, of course, can be unitarily considered, and then to the development of administrative law in Australia and New Zealand. And we hope that today's occasion will provide us with further insights and possibly comments, especially on this part. Finally, an entire paragraph is dedicated to global administrative law and to the various regimes of international regulatory cooperation. Having provided an introduction to the various legal systems in chapters 2 and 3, the following chapters can more fruitfully conduct the specific analysis that Giulio was referring to earlier. So chapter 4 is dedicated to the analysis of the several functions that public authorities carry out in order to pursue the public interest, and also to take care of the essential interests of the community. This, first of all, includes the analysis of core public functions, such as the ones related to public order, to the control of the borders, to the entry and treatment of foreigners on the national territory. And examples are provided, for instance, by the travel bans issued by President Trump already in his first presidency, or by the legal treatment of refugees in Europe, an aspect that is only in part harmonized by European Union law. We then move towards public services. In fact, also in most liberal traditions, beside exercising core public functions, modern administrative states are to a significant extent direct or indirect public services providers. These services are typically instrumental to the protection of social rights. And in fact, the chapter analyzes some of these services, such as, for instance, healthcare provision, healthcare services, which can be provided and organized on the basis of very different healthcare systems, also on the basis of the different conceptions of the protection of health at the constitutional level. Also, access and the preservation of natural resources represent duties that, especially in light of the most recent constitution, the administrative state has to carry out, and that's why we focus on them. And these and other public administrative services and functions, which of course also include rulemaking, can be delegated and distributed, let's say, to various public bodies, among which a special role is played by independent administrative authorities. And within the latter, a specific role is, as it is well known, played by authorities tasked with financial and banking supervision, to which a distinct paragraph is specifically dedicated. Furthermore, functions can also be delegated to private subjects, provided that certain conditions are met, and we take due account of this. And with this regard, significant examples have been brought to the attention of comparative administrative law, especially by legal scholars in the US. But I know that I don't want to run out of time, so let me move to chapter 5, which is dedicated to the comparative legal analysis of the activities that public authorities carry out in order to fulfill their duties. As it is well known, administrative action can take many forms and follows legal regimes, which is, at least in part, differ from the ones regulating relations between privates. To clarify this concept, we refer to the historical supremacy of the administration that initially characterized most legal systems, at least in continental European systems, and to provide some theoretical background and structure to the analysis. The chapter recalls some categories and concepts. For instance, we distinguish administrative action that takes the form of unilateral decisions, the theory of the administrative act or decision. We distinguish them from consensual means of action, such as agreements and contracts. But also we distinguish between individual measures and those of general application, between adjudication and rulemaking. And moreover, public authorities can, of course, exercise a varying degree of discretionary powers. And their action must comply with constitutional principles, general principles of law elaborated by courts, and with procedural rules, which to an increasing extent have been codified into administrative procedure acts. We also take account in this chapter that certain legal systems have introduced sophisticated requirements, such as the cost-benefit analysis, various forms of impact assessment, and regulatory impact analysis. Then also other forms of guarantees that occur when general measures are adopted, that is the débat public, public inquiry, notice and comment procedures, and so on. Of course, due account is taken of the fundamental principle of due process, which is in principle recognized in every legal system, although the way in which it is actually enforced differs significantly. And this can be said in particular for the duty to give reasons, for the right to access to public information, as well as to the actual implementation of the principle of transparency. Specific rules then, of which we make a brief explanation, regard public contracts. And these rules have been significantly, as it is well known, harmonized at the European Union level. To conclude this chapter then, finally, we would like to say that when all of these principles, rules are not followed in brief and very general terms, administrative action is deemed unlawful, with a series of articulated consequences of which we take account. And this entails that several remedies can be activated, typically the quashing of the administrative measure, but also with certain limitations and distinctions toward liability. This last reference allows me to jump to the 6th and last chapter of the book, which is dedicated to administrative litigation and judicial protection, which of course benefits from the substantial analysis carried out in the previous chapters. As it is well known, in order to ensure that administrative action complies with the principles of the rule of law and that individual interests and rights are protected, various remedies and tools of judicial protection are established by the various legal systems. Traditionally, in this regard, it is possible to conventionally distinguish systems with a distinct administrative jurisdiction, those with a common one, and still other systems with specialized courts. So the scenario is a little bit more articulated than the conventional dichotomy between monistic and dualistic systems. In light of this categorization, which is useful and necessary within for descriptive and systematic purposes, a common trend towards the specialization of the judicial remedies and procedures, and in part of the jurisdiction, is emerging among the various legal systems. In other words, we believe that the specialization of the procedural rules governing the controversies involving the exercise of administrative powers is, to a certain extent, undeniable. After introducing these aspects, the chapter analyzes the constitutional basis and the supranational constraints of judicial review, as well as the ways in which access to justice can be alternatively broadened, limited, or exceptionally excluded. This also relates to a distinct issue which is particularly relevant in both theoretical and practical terms, which is the alternative conception of judicial protection against the public administration, either in objective or subjective terms. Of course, both components, objective and subjective, are present in the various legal systems of judicial protection, but the prevalence of one over the other, also in a diachronic perspective, entails different consequences in terms of the available remedies, timing, standing, powers of the judge, and so on. I just anticipated that since administrative functions can also be performed by private subjects, in this chapter, we dedicate a specific paragraph to the extension of judicial review to private bodies, which is an issue that is replete with theoretical...
Leonardo, I think I can't hear you, although your mic is still on, but then for some reason you can't be heard.
Can you hear me?
Yeah, we can hear you now.
Okay. I was just saying that we focused on the private exercise of public functions in the previous chapter, and in this last one, we explained the extension of judicial review to private bodies exercising these functions. For instance, taking into account the UK jurisprudence on the source of power test and on the nature test, which has been applied also in other jurisdictions. Then we clarify that once recognized, once affirmed, judicial review can, of course, be provided according to different standards. We explain deference, reasonableness review, proportionality, and as it is well known, of course, here, typically the US and Canada are offering significant news in this regard, but that's just to make an example, of course. Again, moving forward to with the chapter, to ensure swifter judicial review and more effective remedies, several reforms have been introduced in the various legal systems, such as those concerning the administrative loop and other solutions, such as the dequotation of formal and procedural defects of administrative action. And then specific attention is dedicated to judicial protection in the field of the award of public contracts, which is which entails a huge caseload, at least in certain European legal systems. And finally, we examine alternative dispute resolution mechanisms, which represent an articulated group of remedies that sometimes display ancient origins, but that have been recently conceived as fruitful possibilities for remedying to at least some of the controversies between private legal persons and also private individuals and public authorities, but also service providers. And with this, I hope to have given you at least an initial idea of the contents. Sorry if I was too quick on certain ones, but we are glad and open to your comments and questions.
Well, thank you very much for the very comprehensive summary of the book, I must say. Can I then ask Janina if you can give your comments on the book itself?
Thanks, Edward. And I just want to say thanks so much to Cora for inviting me to speak, and to Edward for sharing and saying that I'm famous, which I'm not sure is true, but it's very kind of you to say. So I want to start by congratulating the authors. I think Leonardo's just given an overview of what the book and everything the book entails. And I think it's really easy to see the enormous value in a book like this, that really it maps out administrative law's development and some common issues and themes across the world. So as they note in the introduction, and as I've explored in some of my early work, comparative administrative law as both a field and as a method is less developed than other fields of law, especially private and constitutional law, though not by no means the least developed field of administrative of law. My current focus is on statutory interpretation, where there is virtually no comparative work. So keep your eyes peeled for a book on that. But administrative law has traditionally not been a sort of hotbed of comparison. It's been a bit neglected. However, I think that has changed over the last 10 or 15 years. There's been some notable, really important contributions. So one, of course, is Susan Rose Ackerman and Peter Linzeth's book, which I think is now in its third edition, with some new co-editors. There's also, of course, a Yale listserv of comparative administrative law, suggesting that at least some of us want to sign up to find out what's going on in other jurisdictions. And there's also been a lot more use of comparative methods in the field, and I think that's obvious if you go to the Public Law Conference, where a lot of the work is comparative. But as far as I'm aware, this is the first monograph, or I'm actually not sure if it's a duograph, given that there's two authors. But in any event, it's the first of this kind to trace the history of core administrative law institutions and principles globally. And there's a few things about that that are particularly valuable, I think. So one is that you've got authors who are the same throughout, who are not then trying to corral the disparate interests of multiple scholars into something that's vaguely cohesive. Instead, this allows the authors to take a consistent eye to developments across the world. And another hugely valuable aspect of this contribution, as Giulio mentioned, is that it goes beyond the usual suspects. So it goes to jurisdictions in Africa and the Middle East, which you rarely see discussed, at least in Global North journals. So the disadvantage, of course, of the approach is that they come from their own position, and they bring that analysis to the story that they tell and those biases. And on that note, I, as a commentator, do the exact same thing. I'm equally affected by and limited by my own knowledge and and situation. I come from a common law jurisdiction, which has essentially drawn its administrative law from England, to a lesser extent the US, with some important influences from Sweden. So I do think that's a limitation, but as I said, it's counterbalanced by some really important, valuable aspects that come from that exact same phenomenon. So the authors really do tell a story in this book, a story of administrative law, of its development in different jurisdictions, and they give explanations as to why they think it's developed in those particular ways. They trace how jurisdictions have influenced each other. It is very much a story. It covers an extraordinary amount of ground. I won't go through, you've already heard from Leonardo what it covers, but it begins and ends with Europe, explaining the development of what the author says, a firstly recognizable separate field of administrative law in France and then Germany and England, and how these three major European approaches have influenced and spread in other European jurisdictions. It covers a handful of Eastern European jurisdictions and the effects of socialist systems, as well as more recent moves in some away from liberalism. And then turns to look at the effect of the EU, which is argued to be largely an effect of harmonisation, though I'm not sure how that squares with the modern trend of illiberalism in Poland and Hungary, for instance. As Leonardo mentioned, the next chapter, it outlines even more briefly the story in the rest of the world beyond Europe. It argues that the US offers a distinct model with a distinct focus on participation and democratization of administrative processes, and how that model has been influential, particularly in Asia and South America, while other countries and regions have been more influenced by colonization. So the story of African administrative law, for instance, begins in earnest with colonization. Likewise, the story the authors tell of Chinese administrative law is focused on China's modern day influence in the region and really only starts in the 1980s. The chapter then ends, and I couldn't pass this up, of course, with a discussion of Australia and New Zealand, which the authors describe as at the extreme margins of the Commonwealth. Which is interesting. It's not how I would describe Australia. I certainly concede that we're marginal in terms of global relevance. And definitely, yes, we're part of the Commonwealth and the common law tradition of administrative law. We are geographically distant, but I'm not sure that equates to at the margins of the Commonwealth. Nevertheless, despite the description of us being marginal, there was a relatively lengthy discussion of Australian administrative law, which I found a little bit curious. So the jurisdictions whose stories are sort of are considered, I did find a little bit curious. For example, we've just got Turkey and Israel in the Middle East, India, Japan, Korea, and China in Asia, Brazil and Argentina in South America. I felt that for some of these choices, there were short explanations, but not for all. And I was curious as to why the jurisdictions were chosen. And as Julio mentioned in his presentation, the level of treatment given to each jurisdiction was also really wildly different. And for some, this made sense, such as the big influences like the US, but it wasn't always immediately apparent to me. And that for me raised methodological questions, which I would have liked to see the authors explain in the book, though I admit this would probably make the book far less interesting to most people. And it was a very interesting story. But I think for me, it was perhaps one of the first significant issues that the book raised about the development of comparative administrative law. And that is the issue of whether it's being used as a field or a method, the interactions between the two, and how much method and theory is needed in the former, that is, when it's being used as a field rather than just a method. And I think that going back to the relative lack of attention broadly to comparative administrative law means that those questions are still quite underdeveloped in the field. And in a lot of scholarship, I think there's too little attention to method. So the remaining chapters of the book, as Leonardo mentioned, are thematic, covering issues or challenges that cross jurisdictions. They do largely focus on Europe and the US. And I, again, won't go through them, but the issues are public functions, delegation and outsourcing, the last of which is a theme particularly close to my heart, or maybe the opposite at the moment, coming to the end of a 5-year research project on outsourcing, a comparative project on outsourcing. The second theme I thought could broadly be described as sort of democratic legitimacy processes. And then the final chapter on the extent and nature of judicial review of administrative action. So I think it's really clear that the task the authors took on in writing this book is extraordinarily challenging. I could not have done it. I would not have tried. I can't imagine how much work it took to understand the history of administrative states and administrative law in so many countries, or how many years of work was involved in this. There were discussions of topics that I never would have thought of as tied to administrative law consequences, like specific trade agreements, financial regulation legislation, natural resources exploitation, the independence of central banks, as well, of course, as a lot of topics that I did expect, like administrative procedure codes, rulemaking, discretion, and judicial review. So given the breadth of coverage in the book of both jurisdictions and topics, it necessarily simplifies a lot of very complex themes and histories. And as I mentioned before, the authors have very much chosen versions of a story to tell. So at many points, the version they've told was only one version of something that's contested. And the book doesn't engage with those contests for the most part. So an example is the way they characterize the grounds of review in the UK. Or the book doesn't engage in the nuances of different tribunals in the common law world. So it alludes to formalist and functionalist approaches in the courts, but it doesn't have space to engage with the nuanced debates about whether those approaches are really doing what they say they're doing. And in some places, the brevity and simplification meant that parts of the picture were missed. For example, I thought that, the discussion of standards of review and deference in Canada missed a lot of the nuances of the discussion. However, again, it's a double-edged sword, because I suspect that had the authors left any of what they've included out, they would have been criticised for that. Because, of course, every academic thinks their own research interests are the most important and worthy of inclusion. So I think the authors really were left with the unenviable challenge of trying to cover everything and then not having space to go into anything in very much detail. But the result was that I found there were a lot of issues where I was left wanting a fuller story. And I want to emphasize that none of this is a criticism. Rather, I think it points to the fact that this book is very much agenda setting. It's not a complete history, it's not a complete story, but I think it really usefully points out a whole range of topics that administrative lawyers around the world might want to pursue on their own. In fact, I think pretty much any page you turn to, you could find a research agenda for the next 5 years of your career. Some of the topics that I thought were ripe for further discussion that I picked up, for instance, were the effect of express, regional, and domestic rights instruments on administrative justice and the development of administrative law. There are express protections that the authors outlined in multiple agreements, such as in the EU and in particular jurisdictions. The number of them, I think, leads to a question of whether their impact is uniform. Another one I thought was access to government information, which is touched on in different parts of the book, but I think probably deserves its own book, and seems to me to be emblematic of a potentially quite different approaches, not just to the administrative state, but democracy itself. And perhaps it's something that particularly interests me because we're going through a bit of an attempted shift by the federal government in Australia right now in that space, one that I vehemently disagree with. And another was values-based versus rule-based reasoning in courts and tribunals. And that's just a very short list. As I said, I think you could open almost any page and find a research agenda, and that's a real value of the book as a starting point for comparative scholarship. Another really valuable aspect of the book is the sources at the end of each chapter, which compile some of the key contributions on the different topics and jurisdictions. Though, of course, there were some references obviously missing, largely to my own work. No, it was interesting, though, to see, for example, that of the two sources cited on Australia, one was written by a New Zealander. Normally it's us claiming New Zealanders as our own, not the other way around. But as I said, I come to this commentary from the position of an Australian lawyer. So the story of the book the story that the book tells largely does reflect my own understanding of administrative law, which is French and European centric. But I do wonder how a Japanese public law scholar would tell the story in their own country, whether the starting point would be the same of them being influenced by German and French law in the late 19th century and then more recently American law. Or, how would a Chinese scholar tell the story of their administrative law, or a scholar of Islamic law, whether their starting point might differ and whether they would dispute any of the kind of Eurocentrism that's in the book, or that's sort of really throughout the book. And then there were a few other areas where the book itself left me with bigger questions. So I've already mentioned method, but perhaps the biggest was, what is administrative law? So there's no agreed definition, even within single jurisdictions. And you can see this at its most basic by looking at textbooks within a jurisdiction. In my own, for instance, there's no agreed list of institutions or laws that count. Some books will include parliamentary oversight, human rights commissions, auditors general, anti-corruption, public service commissions. Others don't include any of those things. There's a core agreed upon list of institutions that no one would omit. But even there are disagreements. Is Social Security part of administrative law or its own separate field? Where do administrative and constitutional law split, if at all? And this question becomes so much more difficult when attempting to give an overview of administrative law in every jurisdiction. I'll come back to just over the ditch in New Zealand. They have a very different way of thinking about administrative law. It's public law. It's not split from constitutional law at all. And so even two very proximate, historically close jurisdictions have such vastly different definitions of what administrative law is. It's virtually impossible to define within a book of this scope. But on the flip side, we need to know where administrative law begins and ends, or at least some rough contours, in order to know what we're comparing. And I think that's true if we're doing comparison as a discipline or if we're doing it as a method. And one thing that I took from this book is that perhaps this definitional task is impossible because it entirely depends on the perspective that you're bringing. And that might not be the accepted perspective in another jurisdiction. It therefore might lead you to include things that other perspectives wouldn't regard as administrative law, or to omit things that it clearly would. And difficult as it may be, I do think this is something that the authors and all comparative administrative lawyers need to grapple with. I think, for instance, that a book that takes a very particular European view of what administrative law is, which determines what it includes and excludes, needs to explore that question and explain it. So this book has the unitary state as its starting point, though it's capable of extending beyond state boundaries, as the book's discussion of EU administrative law shows. But it doesn't, for instance, accept non-geographic forms of political organisation and administration as existed across Africa and the Middle East prior to European colonisation. And I think there is a huge amount of scope for exploring and questioning those definitional presumptions underpinning the view of what administrative law is. There are various hints at the answer to this question, for instance, in the introduction and then at various points throughout. The authors make a claim that administrative law is increasingly defined by a set of common values, And for example, in chapter 5, they repeat this claim by saying that in all jurisdictions, the actions of public administration is governed by the rule of law and legality. So this leads to a second of my big questions, which is it true to say that there are common values that that define what administrative law is? I haven't given, sorry, in Australia, for instance, I'd say that administrative law could be defined as the rules and processes that attempt to protect and encourage a particular set of behaviours within the administration, and that those behaviours are defined by values of transparency, accountability, efficiency, fairness, and rationality. I haven't given serious scholarly thought to that list that I've just given, but many others have. And I'd also say that those values broadly represent the way administrative law works. And offer opportunities for defining it in jurisdictions which are similar to mine, like the UK, Canada, and the US, and probably also in slightly more distant jurisdictions like those in Western Europe. It's also certainly true to say that in those jurisdictions, discretion is bounded by the rule of law and legality. But I'm not convinced by this book that these values are shared amongst countries more broadly, especially, say, China and those countries experiencing democratic decline. It seems to me that there may be a set of shared administrative law values in functioning democracies, but not necessarily beyond that. And I wonder if the author's European view of those values in the way that they think about and define administrative law has led them to this sort of circular conclusion about values. So there is another hint at definition in chapter 4, which centres around public functions. That concept's been very well explored, but also much criticised in scholarship and case law. It's a common way of thinking about administrative law, but also runs into significant definitional hurdles, largely based on the fact that it's so changeable across jurisdictions and time, and so very subject to personal views. Professor Anne Davies, a leading common law scholar on government outsourcing, for instance, has said that a public function test isn't much better than a complete discretion as to what one thinks should be subject to public law accountability. So to summarise, I think this book offers a hugely valuable starting point and is very, very much agenda setting. I'm sure the questions that it raises for me are different from those that it raises for others. And this is one of the most valuable things about a first of its kind broad-ranging book like this one. It can't be everything to everyone. None of our scholarship can, and I wish someone would tell reviewers that. Instead, what it does is open up so many issues that comparative law scholars can find an interest in to prompt more work in the field, which I think can only be a good thing. So I thank the authors for the monumental task they've undertaken here, and again, for Cora and Edward for facilitating this discussion.
Oh, thank you so much for the set of comments. I must surely add two things. First, I agree with Janina, but especially about the points about methodology. Sorry. Okay, well, that's probably accidental. I agree about the questions about methodology in reading this book, and also reading in general about comparative administrative law. I certainly had quite some questions about the methodology of it. To the extent I actually wrote something about it, is currently under review. But also the second thing is that I admittedly have been relatively neoliberal about timekeeping in the process, and so we're already over time. I think that my resolution of it is perhaps that I will limit myself to just allowing two questions, if you allow me, from the audience, if there are any questions. So if the audience has any questions, do feel free to raise them now. You can do that if you want to speak, or if you want to type it in the chat box, that'll be fine either way. But if no one wants to do that, I'll give you 30 seconds. But if no one wants to do that, I'll do it. And I would love to do it. But do feel free, the audience, if you'd like to jump in. You're perfectly entitled to raise the question. Well, it seems that the audience has, by tacit acquiescence, agreed that I should raise my own questions. So, so actually, I think there are some concerns really has given me. I think that one of the concerns is the idea that when we do comparative administrative law research, as has been stressed earlier by the speakers, we must look at the context, we must look at all the history, the politics, the economics behind it. And that actually led to me to have a worry, is that even if I study a particular system of administrative law and I feel inspired by it, so for instance, I feel inspired by what Canada has done with deference, or I feel inspired by what the French has done with public contracts, it doesn't follow at all that I can adopt it actually into my own system, even with a variation, because our contexts are so different. And because we have so many factors you apply, so economics, history, politics, and as Janina has given a very good example, even Australia and New Zealand being so proximate in so many things, still have such fundamental divides in how to see administrative law. I don't feel at all confident that I can say that after reading a good piece of comparative administrative law, therefore I can feel inspired to use it to improve my own understanding of domestic administrative law. So that's my first worry about the methodology of how we can actually use comparative administrative law to go back to our own jurisdictions and improve upon it. That's my first worry. My second worry is, in fact, you may say it's related, but it is going with the fact that because to do comparative administrative law, we need to know so much of the background. It is actually, I suppose, it's even very difficult to have a non-obsolete, unerring understanding of a jurisdiction. Because again, if to understand, say, Italian administrative law, I need to know is positive law, is culture, is history, is politics, is economics, and all of these, of course, can be changing day by day. I'm actually not confident that I can know a jurisdiction properly, let alone even more than one. So I'm worried by the 2 points. So the first about the fact that we need to address all the varying contexts when we draw inspiration and ideas from one jurisdiction. And second, the mere idea of just having to understand a jurisdiction properly. That does make me worry, I must say, as a domestic administrative lawyer, to how I can learn from studying comparative administrative law. So these are my worries. I must confess I've already written about them. So these are kind of formulated ideas already. I can't say I'm departing entirely from an open mind, but I'm really curious to see what a comparative administrative lawyer would say in response to such kind of worries.
If I may just provide some comments to your very fruitful speeches. First of all, let me thank Janina for her so careful reading of our book and for the very precious comments she gave. Many of them, I think, are very useful for a second edition of this book, including the loopholes in bibliography and some missing or not fully well explained passages of the text. Just an excuse for marginal with reference to Australia and New Zealand. It was just a geographical statement, meaning the distance from UK, and I didn't make, I must be honest, a calculation of the distance from UK, but I think that Australia is the farthest from the center of the empires, if we can say so. Other comments, on the contrary, rightly address on the choices we made and the absence of completeness and deep analysis that was inherent to this kind of book. Um, First, just I was to focus on two comments, and one is also related to the last question we received. Continents and countries on one side, and the perimeter on what should be in and what should be out. It, it's true that, of course, we try to have a broader view than the usual Western approach, but it's also true that we come from Europe, we come from Italy, so this unavoidably affects our perspective. It would be very interesting to see how a scholar from Japan would map the continent of administrative law. Of course, if we would have mixed together different authors from different jurisdictions, we would have had probably a broader perspective. But I think it's also important that the book has a unitary vision. I mean, there are many books with chapters written by many authors and very important books of this type. But if you do so, you lose the unitarity of the vision, of the speech, of the quality of the text. You raised a very sensitive point about democracy and administrative law, which is, however, also very critical or dangerous because we have different notions of democracy around the world. We have democracies in deep crisis also at the heart of liberal democracies. So one should wonder if at a certain point the US should be kicked out. And from an historical point of view, I've also to say that the development of administrative law was very relevant also during authoritarian phases of Western countries. I mean, the development of administrative law in Spain during the Franco regime or of Italian administrative law during fascism was a relevant one, was part of the history of Spanish and Italian administrative law. So I think it's important, and this is the reason why we made this attempt to provide the constitutional framework and to try to describe the form of government and also the political system, because this is also relevant in our opinion for the evolution of administrative law. But I think it's very difficult to say I will not analyze this country because it's not democratic.
Sorry to interrupt. I have to go to put my son to bed, but I did want to just say thank you
Yeah, thank you so much,
I hope
Janina.
enjoy
You were very
continuing
kind, and we
discussion.
were
Thank you.
late probably, but we are
Thank
going to. Thank you so
Bye,
much. Very
everyone.
good.
Thank you,
We keep in
Janina.
touch.
There will be a recording, so Janina will be able to
Yeah.
listen to the that the reply that you're making. So
Yeah,
thank you.
yeah.
Yeah, Giulio, yeah, please go on. Yeah.
Thank you so much, Cora.
Let's go.
And as it concerns the area, I would like to maintain a kind of imperial conception of administrative law. I love administrative law at the borders, as it was the title, a very interesting book, collective book 30 years ago, more or less, because for too much long time, administrative law was compressed by constitutional law on one side and private law on the other side. So it's a kind of cultural and political statement and position. I want to have a broader view of administrative law, including public ownership and common and natural resources, and as well as state-owned enterprises, because this is all very important for the functioning of the governmental machinery. Even if I'm aware of the fact that in some jurisdictions, the main regulation is provided by common law or by private law. I stop here because we are running a little bit too late, and I leave it to Leonardo if he wants to make some additional comments. Thank you.
Thank you. Thank you very much. I will not steal more than a couple of minutes. Thank you for the very interesting and careful reading that Janina has made, and also thank you, Edward, for your questions. They were big questions, most of them, and we will need some time to address all of them. I really appreciated the different way in which Janina formulated common values, that is maybe referring to shared administrative law values in functioning democracies, with the caveat that Giulio has just made, which is not a secondary one. And I will not go through the other comments, but I can assure that I took notes, so I will address them in the future versions. Whereas, as far as Edward's questions, typically the second one, which deals with the development, the evolving nature of jurisdictions, also in a diachronic perspective and also in a micro-diachronic perspective, that is a challenge, of course, with which also in domestic law one has to cope with. So it is difficult, but the difficulty should not make us desist, I think, from making comparative analysis. Otherwise, that would be we will be defeated by it. So we will take the challenge and try to be as updated as possible, let's say. I hope it, I'm sorry for being this quick, but thank you again.
Thank you so much for all of your presentations, and for Janina as well, who I hope you'll be listening to this in the recording. Thank you so much for your presentation and comments as well. So, and also thank you for the audience for bearing with me. It's my bad timekeeping, I confess, my bad. But thank you so much. I hope you have witnessed the enthusiasm of administrative lawyers at work, and all the very best to the rest of your day, wherever you are.